Yes, today we are going to talk about the last module, module 7, about the cooperation in investigation and prosecution. We mean here the international cooperations and where there is the gaps within the legal system of the Republic of South Sudan. And this presentation will prove to you the significance of having a comprehensive anti-trafficking in person bill to cover all the identified gaps, whether in the areas of investigation or areas of prosecution or transnational organized crime, or the areas of cooperation, whether cooperation inside the country between different law enforcement agencies and the civil societies and the stakeholders, or cooperation between South Sudan and other countries in the region in terms of issues of extradition, mutual legal assistance, joint investigation, and even repatriations of the victims, rehabilitations of the victims, and amongst others. So mainly the presentation will be about the three components. One of them is the cooperations in trafficking in person cases, and the other one is investigation of the cases where there is a need for collaboration and cooperation, and also the same in the prosecutions of the trafficking in person. The abbreviation TIP is referred to trafficking in person. So for the cooperations in trafficking in person cases, it is crucial in the investigation of the human trafficking cases, as they often occur across the borders. Most of the cases with the trafficking in person sometimes involve different jurisdictions. You may find a victim from, for example, foreign country, and the trafficking happened in South Sudan, recruiting happened in the other countries. Where there is a cross-border, there is a dispute of which laws will be implemented, how the investigation team will be cooperating and exchange information. So it is very crucial, because to improve cooperation, the government should establish a legal basis, because you cannot be able to request information from other countries without having at least convention signed or ratified by the two countries, or having bilateral agreement in regard to international cooperation. So you can ask yourself whether South Sudan have bilateral agreement so that it can be help the law enforcement agencies, prosecution, and judiciary in issues of trafficking in person. Again, it is not only enough to establish a legal basis, you have also to strengthen the national capacity. That's why here the task force, with the collaboration of the international organizations like UNODC, manage under the supervision of the Ministry of Interior this kind of training, so that it will enhance the capacity of the law enforcement agencies, the public prosecution attorneys. Further, also it needs a coordination with the international organization. So the country should always be keen to have this kind of coordination with this organization like the UNODC, so that a lot of technical assistance and training and even invitation for the international events will be happening from time to time, so that the capacity of the law enforcement agencies will be enhanced. Then again, also need incorporate of multidisciplinary partners. Like you cannot combat the trafficking in person by one organization or competent authority, like being left only for the prosecutors or the law enforcement agencies. You have to have a committee or a body where all the relevant stakeholders in the institution are there, discuss and sharing information. That's why recommended for South Sudan to have a task force. Now we have the task force in place, but with a limited power. But it is recommended under the bill that they will be having a permanent committee to replace the task force, with the idea of multidisciplinary partners, whereby there is also civil societies and other relevant organizations. All of them will be work with the law enforcement agencies in issues of preventing trafficking in person, protecting the victim of trafficking in person, and also prosecution and rehabilitation and repatriation. There is importance of having NGOs, national non-governmental organization, and the private sector in this effort to fight trafficking in person. To communicate also earlier is very important for the government. That's why we, at the end of the presentation, we said there is important to have a hotline, and also to have committees, whether at the level of the states or at the level of national government or at the lower levels, so that communication will be very early and people will be able to build a trust and use the technology to identify traffickers and the victims, and also provide witness protection. Witness protection, one of the weaknesses also, or the gaps identified, because we have a small phrase about protection of witness, but the mechanism for witness protection, whether to relocate the witness or to provide assistance to the witness or to protect the witness, and also other principles are not well captured. That's why we capture some of these provisions under the bill. And also financial support to help the victims reintegrated. Now it is not very clear who will be supporting Alua, if there is a unit for witness protection or a unit for victim protection, where this fund will be coming from, and whether it will be constant, and every time if there is a victim, whether the unit will be able to carry out their duties. That's why all of these concepts have been captured under the bill. So there is international cooperation instruments that governing the international cooperation of issues of trafficking in person. For example, you have the international cooperation in trafficking in person. You can use, if there is bilateral or multilateral agreement concerning extradition or mutual legal assistance. Now we can be using the signed and ratified Transnational Organized Crime Convention, which is named Palermo, and also we can be sharing information with the United Nations Office on Drug and Crimes. Again, also the other international cooperation that can be used, also South Sudan signed, is a protocol for preventing and suppress trafficking in persons, particularly women and children, because this protocol promotes cooperation through the border and document controls, and also providing for training, research, and information exchange. Other international instruments can be the United Nations Action for Cooperation Against Trafficking in Persons, and the Global Action Against Trafficking in Persons and the Smuggling of Migrants. Because this also action is aimed to protect victims, also to protect migrants, and very close to the impunity gaps for the traffickers and for the Alliance Against the Trafficking in Person. We have other several instruments, like also UNTOC, abbreviation of United Nations Transnational Organized Crime, also can serve as a framework to carry out actions in the absence of the specific bilateral or regional agreement. That was the argument that was given by the task force to the government, that in the absence of or a specific law for issues of international cooperation, let us adopt and ratify the convention. Thereafter, we domesticate. That means there is a need for amendment of some of the provision of some of the laws, and even need for enactment of specific laws to deal with the international corporations in all the criminal matters, because we resolve only international cooperation in regard to money laundering by adopting this principle under the Amendment of Anti-Money Laundering, Counter-Terrorism Financing 2024. And now also we embodied some of these provisions under the bill for the trafficking in person. But what about the other crimes? So there is a need to have a specific law or comprehensive law that can cover all the international cooperations in criminal matters and also the judicial cooperations, mutual legal assistance, so that we'll be able to have clear provision under our laws that can tackle or address issues of extradition, issues of mutual legal assistance, issues of transfer of a criminal proceeding from country to another country, issues of transfer of a sentence of a person, issues of cooperation for confiscation. If there is a confiscation happen for asset which belong to a South Sudanese here commit a crime and then escape to other country, then how this asset can be brought back, which type of agreement that will be used or laws, and also cooperation between the law enforcement agencies. We have, police have some of this cooperation, and we use it for some of cases whereby we were able to take some of the sample related to drugs to other foreign countries, and we get a result. And we have a very good example. In 2015, we have a cooperation with the Rwandan authority whereby we took some of the forged documents and seals and stamp alleged to have been of the government official to Rwanda, and we managed to also convince the Rwandan authority to come and testify before the South Sudanese court. This was based on principle of reciprocity, al-huwa muamala bil-misl. But now there is a change in the Rwandan's legal system whereby the cooperation was taken from the law enforcement agencies to the Ministry of Justice, and they are requesting a memorandum of understanding or agreement between the two ministries, Ministry of Justice in the Republic of South Sudan and Ministry of Justice in Rwanda, to continue the previous cooperation, because the forensic lab of Rwanda is now under the Ministry of Justice, not longer under the law enforcement agencies. So we are still pursuing the letters that to bring the two ministries to have this bilateral agreement on issues of international cooperation. Second, the protocol to prevent and suppress and punish the trafficking in person, especially the women and children, is very important protocol. Why? Because it was passed by the General Assembly with the United Nations in 15 November 2000, with the idea that to prevent and suppress and punish trafficking in person, especially women and children. The protocol outlines comprehensive policies and also programs and measures to prevent and combat trafficking in persons and protect victims from re-victimization. Because if you heard the statement of the Minister of Interior that not to double punish the victim. So here we don't want also to re-victimize the victim. This is based on the protocol. And this protocol also signed, ratified by the Republic of South Sudan. So now it's become as integral part of the legislations of the Republic of South Sudan. For the provision of this protocol, and to get you aware, South Sudan has ratified the protocol. Therefore, it is required as a country, based on the obligation of the country under the protocol, to cooperate with non-governmental organizations, civil society, and other relevant organizations. That's why if you see in the formation of the task force, 22 different government ministries and institutions, plus IOM as the technical consultant, and then also some of the civil society as members to the task force. Why? The reason is to alleviate factors that make persons vulnerable to trafficking, such as poverty and underdevelopment and the lack of equal opportunity, and the anti-trafficking bill, person bill, adopt all these concepts. Because it is very difficult for the government alone to provide, for example, assistance, to provide support, victim referral, victim rehabilitation, or repatriation in this kind of economic situation. So there is a need of having these civil society organizations and even the committed partners so that it can help the country tackle issues of victim protection and victim support and assistance. The protocol also emphasized information exchange, very vital to exchange information, whether within the country or with the other countries. So one of the techniques also exchanging of information. So we have to have at least forum where we can be able to exchange this information, and then also agreement where we can be able to train our staff, whether in-house training or in abroad, so that they will gain also the same capacity and skills, and their attitude will be able to change, and then they will demonstrate who are good performance and protection of the victims. So enforcement, law enforcement, immigration officers, and other relevant authorities are very important to be trained to determine whether individuals crossing international borders of South Sudan, for example, with or without travel documents, are perpetrators or are victims of the trafficking in person. Because sometimes, based on the experience, you may find victim is being considered trafficker or being considered offender because he illegally entered the country because of absence of the interviews and investigation and victim identification. So at the end, you may hear that the victim is being deported back without any further interview, without any further investigation. At the end, you stop the law enforcement agencies or the other agencies to collect the evidence against the traffickers who recruit the victim and smuggle him to the country. So deportation is not advisable, need a lot of interview and investigation. Additionally, training also may change because training is supposed to be focused on the method that can be used in preventing traffickers and also prosecuting traffickers and protecting victims' rights, considering human rights and child also rights and gender sensitivity issues, and encouraging cooperation within the non-governmental organization and civil society. So if you are putting curriculum for the training, whether you are in the Ministry of Justice or in the law enforcement agency, you have to consider this area so that the law enforcement agencies and the public prosecutors and even judges will be fully aware about all these issues. So suppose if there is direction for training, training will be directed in this area so that we can help who are combating trafficking in person. So according to the protocol provision, South Sudan should outline its border measures. This is for those of Directorate of Passport and Immigration, aiming to strengthen the border control. I know most of the smuggling and illegal entry to the country happening in the border. So it is the country to make border measures to strengthen the border control so that they can prevent and detect the human trafficking. So adopting legislative or other appropriate measures is one of the way to enhance the border control. That's why also Task Force is egging here that the Passport and Immigration Act of 2011 is supposed to be reviewed so that to find whether the measures for border controls is enhanced based on the protocol. So this is one of the areas for domestication of the protocol, the need for review of the Immigration and Passport Act. We try another way to address some of these issues through the Trafficking in Person Bill of 2012. So most of these measures, obligations, mentioned under the protocol has been addressed, and sanctions have been provided for the violation of this obligation. That's why you may find trafficking in person is not only one crime. You may find there is a trafficking in person, trafficking in children. There is also aggravated factors that can severe the punishment for the trafficker in case if the victim is children, or if the victim is disabled, or if the trafficker is a law enforcement agency or public official, or if the trafficker are organized crime or syndicate. So you will not be dealt as like one body or one person and traffic somebody. If it is happened by an organization or organized crime or a group of niggers, then the sentence must be severe, not as the other sentence. And also there is a punishment for the legal entity that involved in trafficking in person, whereby the managing directors or the shareholders of that body, if it's happened beyond, they contributed, they will be personally, legally bound and also punished. And even the organization will be also subjected for liquidation and even for confiscation of the asset. This is a lower kind of the sanction that have been brought under the bill and supposed to be enhanced and accepted by the government. So the bill considers strengthening cooperation among border controls agencies by establishing and maintaining direct communication channel. Domestication of this bill required that the country should review all the laws that related to migration, laws related to passport, and even so that issues with illegal entry, smuggling, become severe sentencing against whether the individual or whether the legal entity involved. So based on the provision of the protocol, the country should be responsible for ensuring the higher quality of the travel identity documents they issue, so that our passport will not be easily forged, and then people will be using for trafficking of the victims and for illegal activities. So we have to review whether our passport is very strong and will not be given to any person because you will not know whether this person will be misused over this document. And then again, we have to have labs in place whereby if there is issues of forgery of this lower document, it will be easily detected. I come across one day going to Europe, and then we get our visa in Ethiopia, but there is a lot of check in the visa to the extent that at once they will be like trying to see to touch the visa, and even to see with a smaller so that they will be able to detect whether it is forged or not. And then also they will be see into your eye and see into the picture, and then again they will be talking with you because in some areas there is also the eye detector. We went to Dubai. We conclude the visa normally, but when we go to the migration officer, they say no, go to the machine. You will not be talking with somebody. We went to the machine, and then they say, see to the machine. And when they see the machine, and then the machine automatically detect who is the person in front of the machine, and then all my, my documents and even the passport appeared, and they said, welcome to Dubai. So I am asking those of migration or South Sudan, do have this kind of system in place, and why? And why still this time you don't have this kind of system? So they must also verify, along the government, the legitimacy and validity of the travel or identity document issued or controlled or purported. So to have been issued in their name and suspected of being used for trafficking in person upon request. This is the mandate of the passport and immigrations. So if there is a lot of reform that will be carried out and even enhancement of these measures, need to review their laws and even the mandate of the directorate and able to provide also the support that they needed. So the TIP protocol also delineate the legal foundation for reciprocal legal assistance, extradition, underscore the significance of the organized crime convention as the cornerstone of the global collaboration. So it emphasized the need for the central authorities to communicate with the competent authority. It is the protocol emphasizes the need for central authority, and we decide and explicitly under the bill with trafficking in person that Minister of Justice is the central authority in all issues relating to the trafficking in person. And the same in the anti-money laundering, also Minister of Justice is considered also the central authority. And also the bill established other competent authority, because we are expecting that they will be also like a specialized public prosecution attorney to deal with issues of trafficking in person, and then also a specialized unit within the Ministry of Interior. I was consulted by the minister that this unit need to be established, whether it will not contradict the work of the CID or not, and what will be the name of the unit, and whether the ministry have this power to establish other unit rather than the existing unit, or it will be sub-unit, and which will be the function of this unit. So it is under study. And then also, the other competent authority, like to have a special court for the issues of the trafficking in person. All of them can be established by their respective institution, and to have also mandate that the police will be mandated to have a liaison officer under the Ministry of Interior who will be interact with the Interpol and the central authority. And this we have in practice, but I failed to detect the law that authorized the ministry to assign the liaison officer program to interact. But we need to review these laws to get authorities so that it will not be challenged one day in the court. The important things are all the agreement related to establishment of this organization supposed to be officially ratified by the respective or delegated minister, and Minister of Justice should have copies so that they can be able to argue that yes, we are part to this organization or this convention. Like, unfortunately, the lack of cooperation between these institutions, whereby if you go to Minister of Justice, you will not be able to collect correct information that will identify that which agreements are ratified by the Republic of South Sudan or signed, because the relevant directorate is not enhanced enough with the information, and even with the budget, as you mentioned before. I don't know if you problem with our budget. Then again, the gaps also develops into extradition process encompassing the step to involve in drafting and transmitting the request for extradition and addressing the logistic concern. Another problem with extradition, I am not accusing any institution, but in fact, it is very cost. And I don't know from which budget this process is being funded. Like in normal situation, I know if you want to extradite your person back from any country, it will be you to sponsor and to fund, and it is not correct. This is supposed to be the government. That's why some people end up not following their cases, because of a lot of demand that will be requested from him, whether from inside or from outside. A lot of money being paid for somebody to be extradited. That's why issues with extradition, little is coming and not as much. Most of the cases, people manage to escape. Like in the victims fed up because there is no clear support for the institution relevant to issues with extradition. And then even big question, whether extradition will be made directly between the Directorate of Public Prosecution and the Interpol, or suppose the central authority as the Minister of Justice to be involved, and then the process should go through the diplomatic means according to the signed agreement and bilateral or multilateral convention between the two countries, and the extradited person will be having a right to be brought before a competent court to defend even the request for extradition. And then the public prosecution will be arguing why they want this person to be extradited back, whether the offenses is extraditable offenses or not. All this procedure supposed to be illustrated under a specific law. We have to have a good relation with the office with UNODC, so that technical assistance will be afforded to the relevant ministry to draft this kind of laws and even to assist the country. Also, we don't have rules and regulation that can tackle and simply explain to the law enforcement agency or judicial officer or the public prosecution attorney the procedure. Now, apart from the law, we should have also rules and regulation whereby you can find the forms for the extradition. And you know what is the requirement standard in all the countries or according to the international standard, and then you fill the form. So if you go through the Code of Criminal Procedure, you will not find this kind of forms that mainly for extradition or mutual legal assistance. So it will be very difficult when you write only letter to other country requesting them to extradite somebody there. They will not be able to evaluate your request. It is not in accordance with the international standard. So we need this kind of forms to be developed and also to be issued in terms of whether circulars or guidelines, so that prosecutors will be able. I know we have experience where when we were in public prosecution, we were only writing a letter, not to the extent that put all the requirement, whether the agreement we are basing on, whether the evidence that we are requested to be, whether the offense is extraditable offenses, and also information about the accused person and copy of the law and all these things. If you go through the extradition laws or mutual legal assistance laws or the model provided by the UN, you may find a lot of provision is missing under the current legal system. Additionally, these rules and regulations should include, for example, there should be a general checklist for the requesting mutual legal assistance. Also, supplementing a checklist for a specific type of the request. Sometimes you're requesting mutual legal assistance, joint investigation, mutual legal assistance, sharing of information, mutual legal assistance to take some of the sample from South Sudan to be examined by the crime laboratory of the other country, mutual legal assistance to bring witnesses who are there to be testified in South Sudan. So a lot of numerous mutual legal assistance requests. So it is different. And when you're writing for requesting a statement or testimony, it will be different from also requesting or sending sample for other countries. So we are still too far. So there is a need for a lot of training and also the laws to be in place so that people, when they act according to the law and to the international standard. Also, if you issue with a sample that cover not for outgoing requests or acknowledgement of a receipt of incoming requests, and also a sample for authentication certificate. Now, when you're sending a statement with an accused person, it will not be just like public prosecution said, Vienna, this is the case there. No, there's supposed to be authentication of this statement because it will be used for decision whether that person will be extradited based on the extracted evidence that provided by the country. So if he issues Katir fee extradition, we cannot be able to tackle in this law. Then also there is a checklist for detailing the contents of, for example, the ongoing extradition request, the case work planning, and also the United Nations human rights instruments, because in some situations, the country may reject and say, "There must be fair trial in that country. I will not be able to send the extradited person I know they are not convinced about the country system for the trial. I know we have a case whereby when we are pursuing the case here, then it is alleged that the accused died. But what happened? He disappeared, escaped. But what has been brought to the court, a forgery of a death certificate proving that the accused died. Based on the court case, accused died. But the accused appeared in one of the countries alive. And then when we're trying to pursue, we come to know we don't have any agreement with that country. So that country will not be able to send or extradite the accused. And then in due process, accused escaped from the custody of the police in that country. And the case is still not yet concluded because it is doubtful whether accused is alive or not, and there is exhibit under the court. And there is further. South Sudan, the case with ivories, and brought from other country transits through South Sudan. So we have an agreement that we can be able to exchange information or share information or bring other evidence, because some of these ivories were arrested in South Sudan and some of it arrested in that country. And there is a dispute in regard which jurisdiction will be having a lower right to trial, this case. The two jurisdictions claim, and the other jurisdiction say, we don't have any agreement with South Sudan and will not be any confidence that the case will be transferred to South Sudan under which laws. Can you cite the laws that the accused will be accused? It is rather you to send us the case with you here. So case the Phyllis guide. So there are a lot of challenge. So in brief, we can conclude here. بحاجات كتير جدا. واحد, there is importance of cooperation. يعني كلام السيوري ده كله we can say there is importance for cooperation. ليه? For the three reasons. Cooperation, number one, it will enhance investigation. Let us say, for example, this case, we failed to conclude the investigation. Even the other case with the ivory, we failed to conclude this, the trial. And we have cooperation. And then we have also a case whereby we identified assets with an accused person in one of the neighboring countries. And when we wrote a letter for extraditing some of the accused person or to bring the other asset, the reply was, under which agreement or convention you are relying your request. If you don't have any agreement, then it is better for you to comply with our laws, the laws of that country, so that you will send your you agree with the public prosecution there to initiate a case on your behalf, and then you sponsor the cost of the prosecuting in that country. And in due course, we are waiting. We are aware that the government will be supporting all over the investigation. The information leaked to the accused persons, and all the assets were disappeared. So, enhancement of investigation through the cooperation, very important. And then it's strengthening of prosecution. We failed to prosecute the law. And then also in some situations, issues with supporting of the victim, assistance, in the absence of cooperation agreements and protocols, then there could be a problem. You come across a case of where there is alleged victims with trafficking in persons, who are small children, were detected in one of the countries, alleged to be smuggled from South Sudan. Their fathers are not known, even their families and parents are not known. They want to establish whether a trafficker is here in South Sudan or it is a transit, but in the absence of the cooperation agreement and even the relevant law, al-case anamar part way. And we hear and in some of the news, but we come to know beyond a few one of the official and he claimed beyond his name is being spoiled because he did not take any action. He want to also open case against the person who used to talk or used to write nonsense about him. So we advise him beyond it is better to silence, because you by your position, if you come and then say beyond you are going to open the case, then now people will be starting asking why you did not take any action. and it is in the media. So, enhancing investigation, this is the importance of the cooperation. There is importance of sharing intelligence and resources, improve case outcome. Again, unfortunately, sometimes intelligence share, it will and the accused having information, and even it is not very tight. So even we'll use the information against you, who is sharing the information, and then either you'll be compromised and then you're silent, or you'll be transferred from where you there, and then the case will not go ahead. Strengthen also prosecution, coordinate effort, and lead to more successful prosecution. Question whether South Sudan have a bilateral agreement with the public prosecution of the other countries or DPP of the other countries. Question also issue with the support with the victim. Collaborative support also save better and meet who the victim is. Is in case Biana happened Biana victim South Sudanese traffic to other foreign country. Question whether the Ministry of Foreign Affairs, in the absence of getting a lower monthly salary and even budget, do they ready to repatriate back the victim to South Sudan? So that it will be seen Biana some victims were brought and the traffickers identified, and the case is open, or always the victims not being supported. Key challenges in cooperation. These challenges can be summarized into three. In most situations, there is a lack of information sharing. There is also issues of jurisdictional barriers. There is issues of the victim reluctance. Victim already have opinion Biana, whether he reported or not, nothing will be carried out by the relevant authorities. Like the case of the forced marriage, alleged forced marriage, the victim tried to find a support, and at the end of the day, now he was claiming here, any support, and alleging Biana it was one ministry is standing behind over the case. It is not correct. Issues with cooperation and multi-discipline committees or stakeholders will be the one to address this kind. If we are talking about the victim and victim assistance support, they mandate the other ministry. And if we are talking about interview investigation, is mandate of other ministry. And if we are talking about prosecution, also it is mandate of other ministry. If we are talking about international cooperation and repatriation of the victim, mandate of other ministry. So there is a need of having a multi-agency committee or an institution whereby Kul al-Hayada will be addressed. Like in one institution will not be able to address. Then what will be for the country to tackle these challenges, and even to at least in line with the protocol and the conventions. Strategies for effective cooperation. The country should establish inter-agency coordination. That's why there is importance of having task force in place. That task force must separate. It is not only one person so that it will be targeted and replaced. No, it is like a multi-agency committee where people will be sharing information, capacity building, and even in the interview and prosecution, all these things. So interagency coordination will facilitate information sharing. It will not be from one person to a different institution. Then also joint operation among law enforcement agencies. When we talk about law enforcement, it's not one the type of the police. Police, UNR, national security, other organized forces inside, and then also social service will be coming from a certain department, and then NGOs. That's why there is important to support the multi-agency or interagency coordination. This is one of the strategies to combat trafficking in person. The other strategy is to develop victim-centered approach. That's why we have been talking about victim referral, victim support, victim assistance, victim rehabilitation, victim repatriation, and it is involvement of different agencies, different organizations, different civil society. So the government should prioritize victim protection, support, and empowerment in the trafficking in person investigation and prosecution. The other strategy which is very also important, it strengthens international collaboration through whether bilateral agreement or multilateral agreement or signing the relevant convention. And I do think that South Sudan is going to the right direction by ratifying the conventions and the protocol, and even accepting to draft the bill, which is now before the Minister of Justice. So it will foster cross-border cooperation to disrupt the trafficking network and assist the victim. In terms of investigation of trafficking in person cases, Al-Kalam Gutu Gebel is very important to be noted to all the law enforcement agencies and even the prosecutors and civil society that the Minister of Justice and Constitutional Affairs, based on the current legal system, is the one to assign designated public prosecution attorney to oversee the police service investigation in South Sudan. And the public prosecution attorney must sanction the investigation so that the investigation can be continued. Lano play a very crucial role here. He has to play, and not to stand aside or to stand with the traffickers because of the some little benefit that can be brought to him. No. It is mandate of the Constitution to carry out duty diligently and professionally. So since he is deciding to sanction the investigation, he should not or she should not he should not abuse the office. I am not sure whether there is people abuse their position and office, whereby they ignore the victims' support or victim assistance, because allegedly was said Vienna, the case of alleged forced marriage was dismissed because of that it is against the norms and tradition of certain communities. It is not correct. But it is alleged by the victim that the case was dismissed because of this argument. So it is up to the victim to go ahead to see in the contradiction of the custom and tradition with the provision of the law, which provision will prevail. It is very clear the law and the constitution. But how come somebody will decide no? It is in accordance with the tradition and custom, therefore, and you cannot claim there is a forced marriage or there is an early marriage. Forced marriage and early marriage is criminalized under the Child Act. And even also it is prohibited under the Constitution. So from where you come with that kind of the decision which is against the Constitution provisions and the law. So very important for the public prosecution attorney when sanctioning the case to put into mind all these provisions of the Constitution and the law. The public prosecution attorney can conduct investigation in some situation if it's deemed necessary, but in this situation, investigation is supposed to be under direct senior Vitao, so that he will be considered as the investigator, not longer public prosecution attorney, and will be going and testify for the investigation he carried out. If you want to further search, you can go to section 52, 57, 58 of the Code of Criminal Procedure. Investigating technique, they come very important. As a prosecutor and as a law enforcement agency, you have to be aware about what can be consisting technique that you have to use for any investigation or prosecution, so that you can be able to reach to the traffickers and also will be able to support and assist the victim. One of these techniques is victim interviews. Victim interviews into technique muayyan, so that you will be able to sympathy with the victim to the extent that the victim will trust you and will share out all the information that will lead to the organization or the syndicate or the people behind it. But if you are very arrogant and sometimes you are not sympathy with him, he will not be disclosing all the information. So you have to go ahead, search the internet to find what are the victim interview technique, so that you will be using in your investigation, so that you will be able to conduct a sensitive and a trauma-informed interviews to gather a critical evidence. Like sometimes people will only resort to what have been written by the police investigator, and then based on what decision. No. For example, some of the case of gender-based violence, and somebody will be saying, this person was requesting me to bring water to his room. And when I brought the water, then he raped me. Then you have to go ahead so that to establish, for example, the relation and how many times they are communicating together, and which time, and all these things, so that you will be able to gather crucial evidence. Collecting with the evidence also feed into technique. Then also, if you want to enhance your capacity as a prosecutor or investigator, also you have to know also the technique of collecting evidence. It's not only basically the police recommended and then khalas you say it. No, you have to teach yourself. Learn from a different website and different laws to see what type of technique that can be used, so that you will be able to collect. Sometimes you find the evidence through the receipt with a traveler. Then it will lead you to who is behind this scheme for trafficking in person. Sometimes you can from carefully document and preserve physical and digital and testimonial evidence. So you have to read, analyze, compare, so that you will develop a technique, and then you will be able to decide. Collaboration also very important. Don't do investigation only without sharing information with the relevant and competent other authorities, so that from there you can find some of the very important information that will lead you to conclude the investigation or prosecution successfully. So coordination with the law enforcement agency provide us to build a strong case. That's a technique. Gathering evidence also need also 4 things or 3 important things. Number 1, you have to identify the victims before gathering evidence, because most of the information you can get through the victims before going to the witnesses and the accused. So for the victim interview is very potential, and to get who are some of the testimony that people who you can be summon them. And then analysis is very important, and even the financial records. Issues with trafficking in person sometimes involve different jurisdiction and victim being transported from place to place, and from a single invoice of transportation agency you can get information. Don't ignore. We come across one of the investigations with FBI. Somebody alleged miss, and then it's not very clear whether he was assassinated or was killed, because last time she was seen in the office and then disappeared. So it was she was not reported to the home, and whereabouts was not known. And then the police and the prosecutors started investigating. Then they collecting information without arresting somebody, any person, to see the last moment they saw the victim, and how come the victim disappeared. So it was confirmed that the victim last time was taken by one of the drivers in the company to going to home. And the driver allegedly said she dropped the victim in certain area, and he did not know whether the victim went to house or not. So he claimed no any connection with the disappearance of the victim. So the people, the investigators, went through the road that used by the driver to see whether Al-Kalam few sense or not. The investigators there, they have tools and mobilities. When they want to go to some area, they want to ask you to pay for the transportation and to go, and even all these things. So they went for 3 hours. They are, or driving and observing along the road to see whether there is suspicious things around the road until they come across the traffic police. طبعا traffic police هناك ما زي حقنا هنا. لو في any fine لازم to be recorded and at times that بيكون معروف and the receipt will be provided. ما بس كلام بتاع خشم كده وكتب بطريقه كده. And this kind of recording there will help in the investigation. So they ask the traffic officer in the road whether he observed the driver coming here with the girl. So the traffic officer confirmed that yes, at this time, this person came with the girl to this destination, and there was like a contravention of traffic rules, and I am the one who fined him, and this is the receipt. So when they compared the statement with the driver, they found the driver allegedly the victim dropped before coming to that station. So Manai is lying. This is one step through the analysis. Then again, the traffic officer give information that the like vehicle something not it is suspicious about one of the tires with Arabia Lasati. So they went to al company there to confirm whether there was a change in the tires of the vehicle or not. Then they confirmed yes, Al driver alleged one of the tires and got a spoil, so he requested another tires and we gave we changed. Lakin the good enough they have a system. If there is alleged tire damage, then the damaged one you will bring and then will be kept in the will be kept in the store. So they went to the store, yes, he bring another tire. So because he's suspicious, why he only that tire change. So they went ahead through the road to find whether the theory of whether he concealed, he killed the victim and concealed. And if it's happened he killed the victim, what will be the rationale for killing a lady? Maybe he raped and then to conceal the crime, he concealed the body. But if he concealed the body, they want to call a variance, and provision, and they are analyzing. So they went to a place where they suspected maybe if he want to conceal the body can be in this area, this bush. So they went and they found where the body was concealed there. Then the role of the crime, what do you call Nasbita crime scene and forensic, they went there and they took the body, and unfortunately they found that there is the victim was like crushed by the vehicle, and but there is a element with the tire, asar bitau mojud the body. So it was taken to the mortuary and to the crime lab, and it is proved the type of the tire is belong to one of the trucks. So they went and compared the one, yes, that brought in the store, and they confirmed that it is the tires of that vehicle. So they able to prove through two things: the receipt and the tire that the accused involved, not witnesses. And I sometimes people dismiss cases because there is no witness. Victim identification also recognize indicators and conduct a sensitive interview, provide immediate assistance. For the prosecution, Gibel Zemaguna, very important statement. Alowaguna, the Minister of Justice and Constitutional Affairs, is the country prosecution authority. The same time is the one designated public prosecution attorneys. It is not a DPP. And if you are talking about the DPP in the Republic of South Sudan is consists of the minister. So if there is a DPP, is a minister. Those who are working are assigned by the minister. That's why you find, for example, our colleague, the former director of public prosecution, is not longer DPP. Is the consul general to one of the civil litigation department. So it will be the minister today can assign you to be a director of public prosecution. Tomorrow you will be any legal counsel in any institution. So the Director of Public Prosecution is not longer independent, and it is within the strategic plan of the ministry that looking forward in the future, the department will be independent from the executive, and then by then you'll be having like secure job. So if you want to end as a prosecutor, you will end as a prosecutor. Nobody will entrap you. Because sometimes people love to be public prosecution attorney, but because of the decision of somebody, then you will not be in the service. Then, therefore, the Director of Public Prosecution Attorney is not yet achieve a independency. And then you can go to the Constitution to see that, and it needs a reform or amendment of the Constitution and the law so that you will be having a independent. Also, the legal framework, the Belgium Aguna, so that you can be able to provide international cooperation, need the domestic trafficking laws, international convention, and victim center approach. And we said we give a lot of information about this one. In terms of, we said we are now a comprehensive legislation. Now we provide the bill. International cooperation, we ratified the relevant convention, the Palermo Convention and the protocol. The victim approach centered, we imported all the information under the bill. Prosecution strategy for the prosecutors, you need to have a effective prosecution approach and overcoming evidence challenges and victim engagement and support. So you have to utilize the specialized trafficking in person investigation technique and victim center, and then leveraging corroborating evidence and witness testimony to build strong cases, providing comprehensive service and protection to engage victim participation. Victim also protection need from the country the safeguarding victim and a comprehensive support and empowering survivors. So ensuring the safety and the well-being of the trafficking victim, and then also providing access to social, legal, and medical services, and also enabling victims to rebuild their lives with the dignity. Data Mankolo are the concept for a victim approach, and this needs provision, enabling provision under the current legal system. And the good enough, we put most of this under the bill for trafficking in person. So, and then to conclude, this is only two slides, then we will open a room for questions and comment. Based on the model, it is very excellent to the extent that all the gaps identified are captured under the model. If you go through the model one by one, chapter by chapter, and paragraph by paragraph, you will be having like the whole picture about how to combat trafficking in persons. All the relevant conventions are in place. All the relevant sections, the limited one within our legal system, are in place. The concept with our prevention in place. The concept with our protection and support, and even rehabilitate and repatriation are in place and in line with the protocol and the convention, Alua Ainagazin Palermo Convention. And then even issues with the technique with the investigation, technique with the prosecution, technique with the victims approach are in place, even issues with interviewing. So for the time being, I can say that this manual to be validated, and thereafter, if we discover some missing paragraph or information, it will be easily added. Now, it is not a law. It is like a guidelines that can guide lower investigators, prosecutors, public, even the judiciary, and even those of social welfare, social workers, and even the international organizations that are willing to support and who are combating with trafficking person and even victim approach. So we can say we are model 7, particularly because I was assigned to give this presentation. Model 7, in brief, it is emphasized the importance of international cooperation, and I demonstrated to you the importance and how we failed to conclude investigation, prosecution of some of the cases because we lack this international cooperation, whether agreement or convention or multilateral convention or bilateral agreement. So you cannot be able to fight trafficking in person alone as a country or alone as one department. Multi-agencies approach very important. So it is emphasized this area that international cooperation in criminal matters. That's why we recommend, apart from the bill, we should have a lower mutual legal assistance and extradition act to be put. And here, the recommendation is we need a lower technical assistance as a task force so that we can be able to liaise my ministry with the Interior or Ministry of Justice so that this act will be also seen later. Particularly in combating human trafficking cases involving foreigners. Foreign victims, like we are saying, Vienna, victims are being smuggled from abroad, other countries, foreign countries, to South Sudan. Mahina problem with a conflict of jurisdiction. You will not be able to tackle this one within only your own laws. So you need the laws that enable lower cooperation, to enable sharing of information, to enable lower mutual legal assistance, all these things. Point number 2 also, Al model, in particular 7, emphasize the need for collaboration. You see us based on this demonstration, this fighting of this heinous offense without collaboration, it will be very difficult. Need a lower collaboration between the law enforcement agencies and also the public prosecution attorney or prosecutorial agencies, as well as to be proactive. To think ahead before something happens, approach so that you can gather information from other agencies. So you'll not be only sitting in your office and then conclude the ongoing investigation by just reviewing the case diary without having any communication with the relevant agencies that you have to gather some of the information and analyze. Intelligence information is very important. You cannot be using as a evidence, like it can direct you and unveil some of the unstated testimony through the records. To gather information from other agencies. It is also, based on this model, it's also emphasized the importance of referral to the relevant government department and NGOs. Like some cases, you are a prosecutor, like you need a victim to be assisted, victim to be supported, victim to be rehabilitated or to be put in shelter. It will not be your duty or responsibility. You have to communicate with the relevant department, relevant and committed, accredited organization that are working in this field. So it will be your duty to communicate with the other relevant government department and the NGOs for comprehensive assistance. Without having all of this knowledge in place, victim will not be supported. You will be only based concentrating. You want to put the accused, and then some people will come and then say, "Bianamafi evidence," and then under influence or under threat or under compromise, then you release the accused person. And then you did not go ahead to go and investigate and interview victims and all these things. And at the end of the day, Kalas, you said the case is not longer, and basically you will find somebody step in and then decide and dismiss the case. A multidisciplinary approach is crucial also, as I mentioned before, for effective coordination and service provision. We have a task force, also because of the challenge of meeting every month, because for the task force to meet, and every month 22 different government institutions require the cost معناه في hall will be يعني hired, في lunch will be provided, في what do you call water and some of the snacks, and also so that people can be sharing information. Like unfortunately, we no budget. Where is the budget, and who will be paying? One day, we like use our facilities in the legal administration, and it has become easy for the members from time to time to meet. Now I'm no longer there, and I doubt whether that facility can be easily approached. So multidisciplinary approach crucial for the effective coordination and services, and there is a need for the support to be given to the task force to resume the monthly meetings so that they can be able to achieve the objective of multidisciplinary approach. Good enough, we get like promise from committee donors that they will be sponsored like 4 meetings. One will be in December, and the other 3 will be in the next year. So we are looking also for other partners to support. A lot of meetings, the one people can come, but they will start claiming there is water, and then you will be the situation from where you will bring the water. You will not be paying from your pocket. And then some of them will say, I don't have a transport, and I want to go to it, so you have to also pay the transport. And then some of them will be saying, well, I have a problem in the house and something like this. So at the end, if you, as the president or chair, you'll be facing any time you are taking money from your pocket, while in the time you have been for more than months without even getting. So the small you put for your family will be end up the activities which is not relevant to the future of your. So in conclusion, the slide, that our recommendation, and this is our thought. We are saying the proposed laws, another one we recommending laws to be enacted. Task force, and we are urging the government to consider these laws and to request through the relevant and competent authorities technical assistance from the UNODC. We oblige to appreciate the support given to us by the UNODC. Most of these activities would have not been concluded without this support. We went to several countries abroad. We attended several international conferences, a lot of capacity building. This is because of the UNODC. And even the ratification of the conventions we are talking about, and even the protocol, even with the support. Some people can remember, we have a conference were held in Crown Hotel when we are doing a wider consultation for the ratification of the Palermo Convention, and thereafter also support for the validation of the what do you call the bill, and then there is other support from UNDP for the ministerial committee of 8 ministers, so that they will lobby for the ratification of the conventions, the 3 conventions, and also the support from the enabled ministers with the interior and ministers with the justice, and even the Minister of Foreign Affairs, who took courageously and went to His Excellency the President and convinced, and then went to UN to put the signatures of the government and commitment, and thereafter resemble in the deliberation of the 3 conventions and the protocol in the Council of Ministers and in the Assembly. And we were invited there to also to convince and to do lobby until it was ratified, and also follow in the office of the President until the letter was deposited. So all this achievement, this is because of our committed partners. So the proposed laws and rules and regulation should be enacted or should be passed so that it can provide a comprehensive guide on the process of processing extradition, mutual legal assistance requests, لأنه as you know أنا ما عندنا law in place. We are trying using all the little information we have or provision. Then also we need provisions to be like proposed under whether the Code of Criminal Procedure or the Migration and Passport Act or the Police Service Act or the Penal Code as relevant enough that can have a provision on logistics, who will be paying in terms of issues with extradition, mutual legal assistance, and even travel arrangement and cost. One day we requested to travel to one of the country to solicit to gather information and to have like a bilateral agreement. We don't have a budget in the relevant ministry and other office sponsor to budget. But when it was decided that people will go, another people who went, not those who propose. So they did not bring any information. When they have problem, that's where some of people get chance. I don't know if you يا بقولوا بعربي شنو الجمل يجلب This is always happening, always happening. We hope Yana it will be stopped one day. Then again also أنا بنقول application بتاع United Nations Human Rights Instruments very important and tremendous enough so that this kind of training and capacity building should go ahead, and attitude with relevant stakeholders will be changed, and then أنا بنلقى enhancement of the performance and due diligence. Then we are urging that the government should expedite the passage of the Anti-Trafficking in Person Bill 2024. لأنه كل الgaps identified, we try to mitigate or to alleviate some of these gaps within that law, like it looks require another laws. So this one should be expedited so that it can be passed. And then to enable that, the NFA proposal with establishment of the anti-trafficking committee instead of task force, and also secretariat and coordination committee at the level of the state, so that issues with coordination, sharing of information, cooperation will be very easy, and multi-disciplinary stakeholders. The government also should conduct a capacity building and raise awareness among the law enforcement agencies, prosecution or prosecutors, the judiciary, the public, and the civil society organization. It is not only this. I come across also the promise from UNODC that also they want to conduct this awareness at the high level to the constitutional post holders and even to the members of the assembly, so that they will also be conceptualize the idea, and what we have been saying here today will be one day recognized and passed as the laws in the country, so that we will have a better future for the coming generation. We lost. And now we have been born in war, grow in the war. We don't know whether we will continue in the war. Again, we are hoping we are a national vision Warana. We will not suffer as we are being suffer. And the government should conduct capacity building and establish the anti-trafficking hotline. As of now, it will what does it mean by trafficking person, and the importance of having a legal framework in place, and dedicated officers, public prosecutors, and all these things. Like at the end of the day, for somebody to report benefit trafficking hazard at Labara, for example, in this area, it needs protection. It needs also a hotline where information will not be revealed or linked, so that it will be safe. And for him to be known by the traffickers, is the one giving this information. It's dangerous for him.